Preamble of Indian Constitution. The preamble is based on the American Constitution. The start of prologue of the Constitution is known as preamble. N.A. Palkavila referred to the preamble Constitution identity card. The preamble is based on P.T. Nehru prepared and pushed objective resolutions which was accepted by the Constitutional Assembly in the 42 Constitutional Amendment Act of 1976 incorporated three more words: socialist, secular and integrity. The preamble declares that Constitution operates its power by the people of India to be a sovereign, socialist, secular, democratic and republic state. It listed justice, equality, liberty and brotherhood as the aims. The date of adoptions 26 November 1949. Case related to preamble: the Pirwari cases. The Pirwari Union cases, Supreme Court decided the preamble provides the key accessing frame ideas, but that it could not be regarded as part of the Constitution. As the result, court of the law cannot enforce it. Kesavananda Bharati, West Kerala State, in 1973. The learned judge determined that the preamble of Constitution reflects the key component of the Constitution basic structure, that some of the Constitution important quality include justice, freedom of expression and equality of position and opportunity. The Supreme Court overturned the lower court decision stating that the preamble is component of the Constitution. It is required to include prelude. The preamble, a portion of the Constitution, summarizes the opinion of the founding fathers. The preamble is neither a source of legislative authority nor a bar to legislative authority. Preface is illogical. The fundamental rights article 12 to 35 Indian Constitution ideal with the fundamental rights. These rights state the constitutional inviolable. The fundamental rights are the basic human rights enriched in the Constitution of India, which are assured to all its citizens. No discrimination is allowed in its application based on race, religion, gender, and fourth. Importantly, the fundamental rights are enforceable by courts subjected to certain conditions. These rights are known as fundamental rights due to essentially two reasons. They are embedded in the Constitution, which guarantees them. They are enforceable by the court. In case of violence, a person can approach court law. The fundamental rights of India. Fundamental rights are essential for everyone. Moral, intellectual growth. The fundamental rights are essential for individual growth. India post-independence era has resulted in the addition of some extremely important fundamental rights in the Indian Constitution. Every citizen of India is given certain rights by law. It's vital to know what they are so that no one's rights get infringed upon. Indian Constitution states the following 6 fundamental rights for Indian citizens: right to equality, right to freedom, right against explanations, right to freedom of religions, cultural and educational rights, right to constitutional remedies. The Indian Constitution originally had 7 essential rights, one of which was right to property, Article 31, which was subsequently turned into the legal right by the 44 amendments to the Indian Constitution in 1978. Right to equality, fundamental rights: right to equality, right to freedom, right against the explanations, right to freedom, religions, cultures and educational rights, right to constitutional remedies, right to equality. The equal rights for citizens and completely safeguarded by the equality. Inequality based on caste, creed, regions, place birth, race, sex strictly is prohibited by the right to equality. Also guarantees equal opportunity in government employment and prevent the government from discriminating against anybody in the workplace merely based on the religion, caste, decent place of birth, place of residency, or any other considerations.